Hello friends, do the police officer really have got rights to arrest you in a criminal case? I will answer this question. See, primarily there are two types of offences. One is cognizable and another is non-cognizable offence. Non-cognizable is up to 3 years usually with imprisonment which carries maximum of 2 to 3 years, and in these cases the police officer has got no right to register an FIR. He has to first approach the trial court, take permission, register an FIR. If he wants to arrest, get a warrant and arrest. But in cognizable offences, Police Act has given them sweeping powers to register an FIR, to investigate, and also to arrest the accused. But again, in cognizable offences, there is again a division. When it comes to the offences which are punishable with maximum of 7 years of punishment, something like cheating or dowry harassment, these kind of cases, the Arnesh Kumar judgment of the Honorable Supreme Court comes into play. That is Arnesh Kumar versus State of Bihar. The Honorable Supreme Court has held that in the offences of criminal offences where the punishment is less than 7 years or up to 7 years, the police officer has to issue a notice to you first. Asking you to cooperate with the investigation, and if you do not cooperate, he will ask you to be present with the documents on so and so date. If you abscond, if you do not make yourself present with the documents, and if you are not cooperating with the investigation, he can definitely arrest you. On the other hand, he can also arrest you straight away if you have committed some kind of cyber crime, which is again, let us say, carrying only 7 years of punishment. Then also he can arrest you, but he has to jot down the reasons for arresting you. He has to jot down all the reasons why arrest is very imminent in your case. Otherwise, you are going to abscond, or you are an interstate criminal, you are a habitual offender. There are various reasons that he has to lay down. He has to jot down, and then he has to proceed with the arrest. And these are, there is a protocol with the judgments of the Honorable Supreme Court in Joginder Kumar versus State of West Bengal and D.K. Basu versus State of West Bengal. These are the catena of judgments where the Honorable Supreme Court has laid down some guidelines for the arrest. So the police officer has got to strictly follow these rules and regulations before making any arrest. Otherwise, he will be liable for contempt for the violating the orders of the judgments and the orders of the Honorable Supreme Court, and is liable for punishment. Up to 6 months of imprisonment can be handed over to him. So these are the things what I told you about the powers of the police officer. So for cognizable offence, a warrant of arrest is not required. Police officer is totally empowered to go ahead and arrest the accused. And for the heinous crimes which are carrying punishment above 7 years and up to life or death, in cases like rape and murder, arrest is compulsory. He has to arrest the accused, and there is no other way out. There is no provision of issuing a notice of section 41 or so and so. Even if you knock the doors of the High Court or Supreme Court, they will dismiss your petition stating that your crime is above 7 years. There is no provision of 41A. There is another section called section 41BA clause. Whenever a police officer receives a credible information pertaining to a commission of offence which is above 7 years to life or death, then he is duty bound to arrest the accused. Thanks, my dear friends.